I'm just going to allow everyone on the panel to introduce themselves. I'm Susan Gault-Brown. I'm a partner with Morrison & Forster, and I focus on both the investment management industry and the fintech industry. So as part of that, obviously, there's robo-advisors.
So good morning, I'm Kristen Snyder, and I'm the Associate Regional Director for the exam program in the SEC San Francisco Regional Office, and then I also co-head the Investment Advisor Investment Company National Program with Jane Jarko. And I think if it's okay with Susan, I'll just get my disclaimer out of the way now, and you've probably heard it a bunch during the conference, but just want to let you know that the views that I expressed today on the panel are my own, and they don't necessarily reflect the viewpoints of the SEC, my colleagues on the Commission staff, or SEC commissioners.
Hi, good morning. My name is Delia Caballero. I'm with E-Trade, and I handle investment advisor and other matters for them. And we've had a robo-advisor in the space for several years now.
Hi, my name is Shah Fizi. I'm a CCO at BlackRock. I'm responsible for Future Advisor, a robo-advisor, and other digital properties.
Great. So let me just say, starting out, we're hoping to have this as a discussion, and there are lots of ways that you can be part of that discussion. You can just shout out a question. You can submit a question on your app, or there are index cards where you can submit a question. And so please feel free. Don't worry about interrupting things. We'd like to hear from you. So the agenda today is we're going to try to go over what is robo-advice, what makes robo-advice different from other types of advice, what are best practices, what are some of the unique challenges that robo-advisors face, and then hopefully time at the end for any questions. So what is robo-advice? I'm gonna set out three things that I think distinguish robo-advice, or what people think of as robo-advice. And then I'm going to ask Kristen to just comment on whether, is that the way she is thinking about what robo-advice is? Is that the way she thinks the SEC or her colleagues are thinking about what robo-advice is and what that covers? So one, there's a digital interface through which advice is provided, like a website or an app. Two, the advice is based on some sort of algorithmic program. And three, there's a minimized role for human interaction. So there's either, in some cases, no human interaction, or there's limited human interaction. So I think, I think that captures probably what most people think of as robo-advice. But I know a lot of different models for providing robo-advice, and I'm just curious, as someone who kind of sees the landscape of what's out there, whether this is picking up everything that we should be thinking of, or is this leaving certain things out?
No, I think it's a good broad place to start, I think. So that's definitely the way that we're looking at it. I think we're seeing, in terms of client-facing models, I would say kind of three buckets, although there are probably more, and Shah and Delia can chime in as well. But we are seeing where the advice is sort of algorithm only, or computer driven only, where the client, from the client's perspective, they're only really interacting digitally or electronically with the advisor. Then we are seeing some hybrid models where it's primarily an electronic relationship, but the client may have access to a human to ask questions. And then finally, there's sort of the hybrid plus, or quasi-traditional hybrid, where the individual may start the relationship electronically, but the results are reviewed by a financial professional where they may be refined. We're also seeing, kind of from the advisor-facing perspective, so more business to business, some white label platforms where the advisor is really just an advisor-branded client portal based on the platform that's produced by another provider. There's sort of the platform plus, where the advisor would have access to the platform and be able to white label it while also receiving additional services. And then We're also seeing some customized platforms where the advisor would integrate its software applications with the robo-advisor's API or the application platform interface.
So one thing I'm curious about is, you know, if someone steps into a brick and mortar advisory storefront and talks with a person, and the person takes down their information and just enters it into a computer that spits out, you know, what the recommendations should be, would that be considered robo-advice, such that this type of things that we're going to be discussing on this panel should apply to that relationship? Or is that considered just your typical non-robo advice?
So I think that it raises interesting questions, and probably throughout the panel, each of the compliance topics that we're going to talk about, that, you know, there's general application, I think, of some of the advice that we're giving today, or the guidance that we'll give today for just a traditional advisor relationship. And you raise a good point, you know, when does it sort of cross the line and become robo-advice? And there's nothing on the Form ADV where you check and say, I am a robo-advisor. So the way that we're approaching this, we have an initiative that started in 2017. We'd actually started some exams in San Francisco because a lot of standalone or startup robo-advisors began, although I think robo-advisors have been around for a while. But we started to look, and now we've done a broader-based initiative through our exam program this year that will conclude, started in 2017, it'll conclude in 2018. But we've kind of gathered our pool of candidates, I think, you know, some from news articles, other lists, you know, of firms that say that they're in this space. And we're trying to get, you know, a good picture across the industry. We've identified, I think, 200 plus firms that are sort of in this space, and our initiative is covering, you know, close to 25%, if not more, in that space. So we're hoping to get a broad-based look at both startups in the space as well as more traditional players that have developed or acquired their own robo-advisors.
Great, thank you. Okay, so now that we know that we're not actually really sure what makes robo-advice different from non-robo-advice, but there are certain things that have been identified specifically by the SEC staff in an IM guidance that they released last year. It focused on three things. It focused on the substance of disclosures to clients, where the guidance talks about how the business model is explained in disclosures, how the scope of advisory services is described in the disclosures, and then also just the presentation of the disclosures to clients. The second area was the client information that is needed to support the duty of suitability. And the staff indicated that one of the salient differences for robo-advisors is the use of a questionnaire. I think, you know, we can talk about whether in fact that's, you know, a real distinction for robo-advisors. But I think the notion is that you fill out a questionnaire online essentially, and you don't actually interact with a human being who might ask follow-up questions or, you know, perceive something about the way you're acting that would help indicate what type of investment advice they should be giving. A second area with respect to suitability was a reaction to client-directed changes in investment strategy. So, you know, the advisor advises that you should be in fund X, and the client overrides that. And how should the robo-advisor react to a client-directed move like that, as opposed to how a human advisor might react to that? And then the third area was effective compliance programs, which we're going to spend some time talking about. And the staff identified that an effective compliance program would include development, testing, and backtesting of the algorithmic code and monitoring its performance. And there's a lot of time spent on kind of understanding the technology involved and understanding how the technology is performing and how you're delivering services through that technology. So now I'm going to ask Delia and Shah just to react to this guidance as folks working in the robo-advisory industry. You know, when this came out, or even since it's come out, how do you think about this guidance and how does it kind of guide what goes on for your businesses?
Yeah, there were a number of things that we thought were really on point, we agreed with. And then there were some sort of like refreshing areas that we hadn't contemplated as well as I think the agency did. The area like, model governance seemed, may have been a revelation to other people. We had sort of anticipated it would be a requirement because of, there's been some cases like Axel Rosenberg, and institutions have been sort of having in-house model governance review processes for the institutional investors that use automation in their processes, though that automation is not necessarily shared with retail investors. And so we just made the business decision and the assumption that that too would apply to us in the retail space. So we had adopted that, a model governance framework where there's like testing of your algorithm, and model approval processes and coding control procedures. The area that I thought was very helpful and new to us as an organization was the discussion about UI design. I thought that was very thoughtful. In fact, there was a recognition that a lot of disclosures are affected through hoverovers and then other dynamic web attributes. And that's something I spent a lot of time on. Like, I'll have debates with the front-end design people, whether it has to be can it be a hover-over, or can it be a drop-down? Can it lead you to Wikipedia? I'm like, no, it cannot lead you to Wikipedia. So like, you start with a hover-over that has, my ideal state, which is like it obscures everything, and it's like a massive legal thing. But, with the design team, you want to find something that's meaningful, land in a disclosure that's meaningful, that takes the user that is interested in the underlying methodology to a good source, but doesn't confuse the user. And I think the agency sort of did a very good job of generating discussion and motivating registrants to meet the challenge of affecting their disclosure requirement with the tools they have, the front-end web tools they have. Yeah.
I would agree. I think to some extent, I think some of us in the space when this first came out, there was a little bit of a desire for reassurance that from a legal standpoint, we're not subject to any sort of different standard than your brick and mortar advisors. And I think the SEC has been very open in discussions on that point. I mean, it is great, the flexibility in terms of how to get to like your disclosure requirements, how you meet your suitability, and there's a lot of variety in that space, and how you gather information. I think there's still some appetite for further guidance in terms of that information gathering for the from a suitability standpoint, because there's there's a variety of ways of how you gather that information, whether it's intuitive or through direct questioning. And it's a little different than in your face-to-face interactions, where you can maybe read the prospective client across the table. There you may be able now with aggregation tools and other technology, you really can arguably infer behavior. And I think another area that's of interest is, and that may be different again from your brick and mortar, is you potentially are giving investment advice that may be very limited, maybe very circumspect, depending on the investor's goals, time horizon. And you may not need like such a huge amount of information about the client to be able to give advice that's suitable. And I think that's another area that I think is of interest to this space.
Yeah, I'm glad you mentioned that. It hadn't occurred to me, but I feel that as well, because we partner with banks, broker-dealers that are usually duly registered, and so they have this very structured KYC process. And I'm like, there is I would like to think erroneous footnote in a 1990 adopting release, or rather proposing release that never made it to an adopting release, describing the fiduciary duty as one of suitability. So like we find we have to marry our process with the suitability process of the organizations we work with, and then of course our program, and I think many of our peers is, model-driven, broad-based. And the portfolios intrinsically, we design them in a manner that they're suitable for a client segment. And if you were to collect all of this idiosyncratic information about a consumer, it's not clear to me that you could make, that it would inform your suitability decision. Like the fact that you have, some number of children and their college age is at some future date may not necessarily be a data point input into your algorithm. Although
It's relevant if you're planning for college.
Right.
If the account is about college planning, that's relevant information. But it may not be relevant information if you're planning for, purchasing a house.
That's right.
Potential. So, yeah.
Delia, when you and I were speaking earlier, we were talking specifically about the questionnaires and the focus on, are you gathering the right amount of information, and what information do you need to be collecting, and some of the unique, I think challenges.
You see in this space. I mean, I was talking to someone before the panel started, and from a business standpoint, you're dealing with a whole different set of people in your organization, at least in the large organizations, where you have people that are very focused on the customer interface, the web experience, and they're coming at it with like, okay, this, we're trying to mitigate abandonment. People want to be very quickly in set up. So the amount of space you can, the amount of questions you can ask, some information you can gather is very arguably limited, or they're just going to abandon and they're not going to open an account. They're not going to go forward with the whole process. So that's the tension push-pull against basically, retirement accounts. You've got to be looking, well, maybe not now after the Fifth Circuit, but we're seeing you've got to be looking at the DOL space and what they're saying in terms of fiduciary duty, and then you're looking at the FINRA guidance potentially as well, and you're looking at like the broader principles from the Investment Advisors Act. So you're trying to balance all that, and again, like I said, you're balancing it also against the idea of what's the customer looking for here from an investment objective standpoint, time horizon, and what type of advice you're giving. You're not creating a whole financial plan, and again, it's important you make sure that you disclose that. But you're not, in most cases, it's not, and in totality, it's a very, limited set of circumstances. So.
Yeah.
So I'll summarize the question. Essentially, it's how does the commission view suitability kind of across the board in light of what we've been talking about with the questionnaires? What information is enough? How far do you need to go? And I'm about to give you a really unsatisfying answer to your very good question, which is, it really is going to depend on the facts and circumstances of the particular client. And I think that's why it is, why we did, and it's scalable and it depends on the sophistication of the client. And, there are a number of factors. I think here, when we're dealing with clients that are primarily retail, not all, but, a number of robo-advisors offer advice to clients with pretty low account minimums. So, and I think it's attracting retail, and I think that's a good thing. I think we want people investing since they need to essentially manage their own retirements in many respects. But with suitability, I think what we would be looking at in our exams, and I think the guidance update gives some, I think, good overarching principles to keep in mind. But it's just, I think when we're looking at these firms, we're looking, are you, based on what you're seeing, and it is going to be facts and circumstances for the firms as well, do you feel like you have enough? And are there any questions in there that might indicate, okay, somebody didn't understand something, and so it's indicating a risk tolerance that might not make sense in light of some of the other answers or information collected? So that's kind of where we're looking at it. But I understand, and I understand the point too, that sometimes interactions with a human, you might not be gathering a whole lot more information. But I think when it is largely electronic, and one point that I didn't make that I think it's worth noting, some of the firms that we're seeing are relying on the Internet Advisor exemption that allows them to register even though they would otherwise be prohibited from registering with the commission. And in those circumstances, really, it is very much an electronic relationship by kind of definition. So I think it's, again, maybe my colleagues on the panel can answer better in terms of what you've seen as good practices, but I think what we're going to be looking at is just simply, does it make sense in light of the services that you're providing and the answers that you're getting back? So.
I think there's a level of common sense. Like, I mean, we do, for example, we do, if the information about the client doesn't necessarily map to the profile they're tracking to. Like, for example, especially when you're dealing with seniors, if you have someone that's a certain age and they're tracking, and based on their answers, they're tracking to an aggressive profile, you arguably should be kind of looking into that. I mean, in my opinion. And we have a process where we are doing that and kind of trying to check in with that client afterwards and saying, and it could be that they just have a very limited time horizon for that particular investment. Again, it's potentially a slice of their larger portfolio. And yeah, I want to do this aggressively because it's $5,000 and, I'm going to pull it out in 2 or 3 or whatever. I'm not in like an income focus, so.
So we have, I think, 2 categories of suitability questions. The first category is whether a digital service is suitable for you, whether you're comfortable with the use of a computer, have access to one, and are amenable to limited correspondence with an individual. And so that's like the first threshold question. The second is in the portfolio construction, and a lot of that determination arises from our modeling from the investment teams. So separate and apart from your apprehensions or confidence with investing, you have a horizon and you have some targeted income. Let's just take retirement because it's easy example that we all know. And we design the portfolio with the intention to design for you to meet what we believe from a investment standpoint you require. Like, what is suitable for you to be able to have income in retirement? And so that is, I think, once you get through the basic questions, we spend a great deal of time on that. And, it may be that where it gets challenging is where the investor's risk tolerance is, they're more conservative than they should be to meet the retirement income goals. And I think in that case, you have to sort of respect the client's comfort level because if you were to do otherwise and follow just your investment opinion, you may find that they will be so uncomfortable with the service that they would just quit and they just can't handle the volatility. So.
I think that in the digital space, that is a challenge. Like as I was saying, where you basically, the customer kind of rejects the advice, right? And that could be like, arguably they abandoned the whole process. Or you do see folks in the space who kind of give the customer the ability to kind of choose a different path, be it, and how you, from a regulatory standpoint, handle that. Because at that point are you comfortable that that's a suitable recommendation on your part to that customer? Or do you need to kind of step out of the space a little bit and say, okay, this is where we're recommending you go. You want to go up one or down one? Here's what the implications are. And arguably an acknowledgement from the customer that they understand those implications. And because going forward, you're going to manage that portfolio based on whatever they decided. So I don't know from a regulatory standpoint what implications that may have, like from an examination standpoint.
Or fundamentally disclosure-based. So if a client has selected, an aggressive risk profile or overridden the system and there's an acknowledgement, I think it's all about documenting that. I think sometimes what's going to cause us to ask more questions is if we come in, we see a recommendation, if we're doing a sampling or something of client accounts, and the recommendation or the tolerance doesn't seem to match with the client's profile. But if there's documentation in the file indicating that the client selected that with full and fair disclosure about what that might mean, then I think you're in good, it's going to cause less questions, I think, from the exam team if we're seeing that.
Yes.
So I'll repeat the question. So the question, I think, kind of at a high level is just what role should compliance play in kind of overseeing the suitability determinations? And I think, again, if we see well-documented client files that have documentation, if it seems out of keeping with the client's risk tolerance or risk profile based on, the information collected, but there's documentation indicating that a client has chosen a particular path, and it's well documented. Again, I can't stress documentation enough in this space. And I think with some of our early examinations, it was interesting to see, because especially with firms that maybe are new to regulation, not all of the documentation was maybe as we would like to see, or we weren't seeing documentation around certain things. So I think just having a good process for retaining, because I think also we were seeing in a dynamic environment, maybe things would go away or they wouldn't be kept in real time, or changes would be made to our portfolio, and it was difficult for us to see why that occurred or documentation around how it occurred. And so I think just maintaining all of that so that you have a trail when we do come in and ask questions, I think it will put compliance and the firm in good stead.
And I'm going to ask Shaw to kind of pick up on that, jumping around a little bit, but I don't want to disjoint things too much. Some of the unique challenges that we noted as a group included how you deal with emerging technologies and what you do with the role of legal and compliance, which is part of your question.
Yeah.
And
Are you ready?
yeah.
I don't know that I can I burden myself in a group this large? It's such a public forum. Learn to write tickets, know what JIRA is, know what the software development lifecycle is, get some points in the, these, but you will be working in a technology company, and they will, if you have a compliance issue, they'll be like, okay, when do you need that work scheduled? I'm like, now? And they're like, yeah, do I need to? Yeah, that's right. So they're well managed. Typically, as in a proper company, they're going to manage the releases and control the deployment, so as not to, to have regression or break the software that's out there, and there's a QA cycle and things like that. So the role of compliance, great question, is you also really have to understand organizational behavior and the way resources are managed. And I don't mean to suggest that people don't want to do the work, but you have to understand how to document your compliance requests in a specification with great precision and clarity, and not sort of iteratively, right? Because they're going to build that thing, and keep contemporaneous records and the tickets, and then approve tickets and do all that time. So I spend a lot of my time, writing tickets, working on software specifications, approving them, reviewing them, and then I'll even do some, I would say quality assurance. I look at the results of what was changed on the site to make sure it met my expectations. So there's a lot of planning, engineering planning, and product. I think the one greatest learning for me was I'm functioning in a role that is quite common in technology companies called product counsel. So you are essentially the counsel for that product, and you're responsible for advising them on a range of things, not just the securities laws, in a way that is anticipates the changes they need to implement. So I'll give you a very concrete example. Record retention. We all know there's an immediate requirement, right? It needs to be readily retrievable within 2 years. So if you're working in a software company, you can't just sort of rely on the utterance and the pronouncement of that requirement. You have to help them develop a query to produce those digital records, right? Give the minimum requirements from whatever the relevant, whether it's 17A3, 4, or 2042, go through the statute, marry it with the data attributes you have in your records, and help them create a query that they can produce records within some specified period that you're comfortable with in the compliance program. So.
Great, thank you. All right, so I went out of order. I'm gonna go back. Okay, this is our best practices topics slide. As you can see, there are a lot of topics. So we don't want to chip anyone, but we may not cover all of them just naturally in our discussion. So if there's something that you have a question about that we're not getting to, please let us know and we'll address that. So Kristen, I was wondering if you could address or start us off at any rate with respect to best practices for compliance programs and also disclosures.
Sure. So I'll give kind of just a high-level description or discussion of some unique aspects of the compliance program that we'd like to see. And a lot of this is captured in the IM guidance update. We worked in coordination with IM in creating and drafting the guidance update because we had conducted exams in the space, and I think some of our observations were useful to supplying the guidance. But, sort of a perennial risk area will always come in on exams and get a feel for a firm's compliance program. And so in addition to, I think, what we would expect to see that's kind of described in the adopting release for the compliance program, we want firms to tailor their programs to the risks and issues in their business. And so the guidance update really attempted, I think, to highlight a few areas that firms should be thinking about that are in the Robo space in developing policies and procedures in their compliance program, just to make sure that those risks are covered. Again, not everything may apply to every firm, so they should definitely be tailored to what your business looks like, but some at a high level that were covered in the IM guidance, and I think are, we would hope and expect to see. And I won't go through all of them because I know you can all read. And so, I'd leave you with the guidance update that we published in February 2017. But just policies and procedures around developing, testing, and implementation of models. And so that would be kind of at the time that the model is being rolled out, what are the policies and procedures around testing? What are sort of, the policies and procedures or the process after the model is rolled out to ensure that it's operating in the way that the firm intends it to operate. We have talked a lot about the questionnaire, so we would hope to see policies and procedures kind of around suitability and information gathering pertaining to the information that's captured in the questionnaire. If there are code changes, how are those documented? How are those communicated to compliance? Does compliance have a role before the code changes are implemented, or are they given a heads up? We've seen, I think, good practices where, and I know that compliance folks are not always technologists, but I think Shaw made a good point earlier, just having a good rapport with development teams, and if there are, again, code changes or changes to the software, what's the process for compliance knowing about them and then being able to test around that? What policies and procedures, I think, around disclosures to clients about what they might expect, and if code is changed, or especially if it could have material impacts on the portfolio. Cybersecurity, which I know is, I think, one of the topic areas that we'll cover later, but just having good data protection, information security protection, particularly because there's, so much of the information flow is going to be taking place electronically. And so do you have good encryption policies? If you're collecting passwords and other personally identifiable information, how are you protecting it? So those are just a few, I think, highlights that we would look for in the policies and procedures in the compliance program. But one other area that I'll just touch on is, especially for firms that are new to regulation, I can't stress enough having sufficient resources dedicated to compliance. Sometimes I think, especially as companies are in the development stages, they're focused on developing technology or a product, and compliance can sometimes be put to the side. And we don't just see this in the robo industry, we see this with tech companies in the Valley as well. But I can't stress enough, it's going to benefit the company, I think, in the long term, or your firm in the long term, if you're really thinking with a compliance mind and a good tone at the top from the beginning. And having a CCO that has the expertise and knowledge in this space, I think is very useful, helpful. It will put the firm in good stead. I can move on to disclosures unless anyone else has.
I actually have a question for you, Kristen. Now that you all, now that the exam's been underway for some months, do you have any insights in terms of, like, not just best practice, but common mistakes that you're seeing, or things that you'd like to see, and does the SEC anticipate that they might issue additional guidance after the program kind of wraps up, or the sweep wraps up.
Yeah, that's something that we're thinking about. Our exams aren't finished yet, but we are trying. For those of you who are being examined, we have a list of information that we're trying to gather, just not only to I think understand about the industry, as well as to gather information about compliance at firms. And so I think our hope would be that we would be able to issue something, further guidance after the initiative concludes. In terms of guidance, I think that was part of the reason that I brought up the point about the CCO and compliance resources, because we have seen situations where compliance maybe isn't a focus at the firm. There are 80% of the staff are software developers, and you've got one compliance person who maybe doesn't have experience with the Advisors Act, helping run compliance. And I think that's a difficult position for a firm to be in, especially if you're subject to exam. So again, we're seeing all different types of robo advisors, and so that doesn't apply across the board. And I think. But I think, having a robust compliance program and enough resources to do the job is really important. And ensuring that you have somebody who truly understands what what regulations they should be following.
So I can talk a little bit about the sort of best practices, and one of the unique challenges, I think, is information security, if I can touch on that. It's one of these areas that, and I'm curious to hear your opinion on the role of compliance and information security, where the agency is, there's been a number of bulletins and proposals, and then there's some areas of the law where, particularly for SEI entities, there's quite explicit technical requirements. And curious what your expectation is for the role of compliance and information security, given that it's such an expertized area that is often directly covered by engineers or NIST people who really know the industry best practice.
No, that's a great question. So separate from robo advisors, we've also, and cybersecurity is a focus area on our robo advisor exams, but we, over the last several years, have conducted a few cybersecurity initiatives in both the broker-dealer and investment advisor space. And this is an area we recognize is really difficult. And so we've tried to kind of put our information about cybersecurity out to the industry as almost an open book test, because we can't get out to all firms. And it's an area where we've really, I think, tried to partner with the industry, because we recognize things are changing so quickly. There are bad actors, and it's very difficult to keep on top of everything that we need to keep on top of in this space. And we get questions from CCOs all the time. I'm not a technologist. My IT staff tell me that this is all okay. How am I supposed to know that? Whether it's true or it's not true. And I think, one of the areas where we see the most, and if you talk to some of the other regulatory bodies that are receiving information and investigating, say, the hacks and by the bad actors, a lot of the ways that folks get into a firm is through human error. And so I think when we talk to CCOs, we're often emphasizing ensuring that you've got a good training program in place for folks, so that if you are getting phishing emails and things like that, people can recognize them. We've heard good practices where firms are employing white hat hackers to kind of sort of test and ensure that employees really are, kind of internalizing that training. Multi-factor authentication, patch management. I mean, there's some basics that you hear about, some of these hacks that happen, and oftentimes it's because the basics weren't followed. But from a compliance perspective, I know also we get questions, often you're working with third-party vendors, and if you get the vendor questionnaire, is that enough? And I would just say, if just continuing to ask the questions, and you had mentioned, I think, having a rapport with some of your development staff. I think being able to ask those questions, and it's great to have compliance have a seat at the table times too.
Okay.
Tall order for
I'm
you?
hearing not directly responsible is what I'm taking from this conversation. So I think I jumped ahead. I'll cover the books and records, trading and advisory topics at the bottom of the best practices, if that's okay.
Yeah, that's
Okay.
fine. Thank you.
I'm all over the place. One, there was recently, there's been a lot of discussion both at the Treasury and I think in the industry about the use of the cloud. This is particularly common in robo-advisors, and probably a few banks, not all of them. And I know that the ICC doesn't necessarily have a public opinion about this, but just wanted to acknowledge that, in many cases, the storage may occur in the cloud or be emitted through some storage facility that is actually, shared architecture, though it may be dedicated just for you, like some dedicated servers you've spun up. And then, even the optimization. So there's a number of like processes in the stack that rely on the cloud, which is, there's like one very prominent vendor, and then, 2 or 3 secondary and tertiary vendors that many people use. And, just wondering like what your expectation is for compliance for use of the cloud. Is it just another vendor? They tend to be very, vendors that are so large that it's very difficult to penetrate and have like complete transparency into their inner workings.
So I think, again, just understanding, so where we've sometimes seen issues is in setting up cloud access, just ensuring that you've got folks who really know what they're doing so that
Yeah.
you're not exposing your data to the deep web or, I think again, and I understand your point, you may not know exactly where your data is kept if it's in the cloud and we're asking those questions. But I think it is like another vendor where you'd want to just understand and make sure that you understand the services that they're providing.
Okay. So like vendor due diligence type process.
Exactly.
Okay. So another topic we wanted to talk about is trading processes. This is, I think, also a disclosure related question, which is in the guidance, it was quite clear that you're supposed to describe your methodologies, right, and any limitations to your investment methods and strategies. In fact, that is the Form ADV would be the obvious place to provide those disclosures. And one of, as an organization, we spend a lot of time surveilling, trying to improve our trading process to keep up with the scale of AUM and client accounts we have. So I think that's one unique thing about robo-advisors is to the extent you're using a trading algorithm and an order management system to direct your orders to an executing broker, you think about trading that large number of transactions a day, you're gonna, you have to manage your scaling issues and be able to manage that volume. It's all automated. There are some firms that they use more sort of quarterly rebalancing and manual processes. But one area that we spend a lot of time on is compliance and supervision of the trading process. It's not just the investment model that's subject to, in our view, model governance, but the trading algorithm or optimization process the firm's using. So it's not just in the implementation, but it's obviously in the output and reviewing post hoc that the portfolios are reviewing independently, that the portfolios have not drifted from your target portfolio. So,
Do you think that's, do you find that unique for the robo-advisor space, or would you put that in the category of just an advisor that has a lot of small accounts, or?
I think it's unique to robo-advisors. It's probably unique to, the only other example I can think of, and they're very different business models, are electronic trading firms. They're doing it at a much faster rate and using, a lot of market data and trading on market dynamics. We are not. We're just trying to preserve the diversification that we believe is correct. But it's good to and important to review at some cadence the output of your trading, to say, independently. We know what the model's designed to do, but is it maintaining the diversification that we had set out to, to provide as a service? So I do think that is probably a unique sort of compliance framework you need, to the extent you're using automation in your process.
Great.
A little bit about, I can speak a few minutes about advertising.
Yes, that would be great.
I mean, obviously, like those of you who were here yesterday, there was a whole panel on advertising, and the regulation is the same. The space from a, again, because you're engaging with folks that are very digitally oriented, arguably, your advertising probably is going to be very digitally oriented. So I think you have to keep in mind what venues you're using to do that advertising, and if you're using other sites, like, making sure you keep in mind like attribution, and again, like, because you possibly could be working with limited real estate, the disclosures to make sure that your advertising is not misleading, false, etc. But again, the interesting thing with the digital channel is, and I think Dahlia Blast talked about this a little bit yesterday, is the idea of it's a clientele that's very much like she said, you take a trip, you're going to look at TripAdvisor. So arguably it's a space that, it's not unexpected to think that the folks that are going to a robo-advisor would arguably want to see, like, okay, how does this advisor rate against other offerings, right? Yet we're kind of right now in a space where that's you've got to be very careful, right, Kristen? So we could, Dahlia seemed to suggest that the SEC is thinking about these things as they're looking at how folks are interacting in the space.
So we're in the position where we have an existing body of rules that we're operating under as OC. IAM's our policy group, and so if there are policy changes, we'll certainly kind of implement those in our exam process. But for the time being, marketing and advertising is an area that we're looking at as part of our examinations, and we are looking at things like testimonials. And I think it's not a new issue. I think social media and we're seeing it with, kind of traditional brick and mortar advisors and just the different ways that clients, I think, want to communicate now. A lot of it is electronic. So I know that there are unique considerations and how do you ensure that you're able to properly supervise the communications that are taking place. I think a lot of that goes down to training. I don't know if there are particular systems that you find useful or helpful in monitoring those types of communications, but we have seen, I think, different examples that I think some firms doing it well, where they're ensuring that folks know, that if they are communicating, whether it's, I don't know, my 20-year-old could tell you all the different social media apps that folks communicate with, but I think we do see firms doing a good job in some cases, really pushing that under the firm's umbrella so that they can review it. I think, but it is a challenge, and I think it is particularly a challenge maybe in this space.
Third-party posts, like the area of third-party posts, is very hard, and chat rooms and community. And it all plays into disclosures. Like I think this space, because again, you're dealing with limited real estate and potentially like folks that aren't going to spend a whole lot, want to get in and out very quickly. How do you make your disclosures effective, plain English and readable? And, as you were alluding, like the idea that in a lot of cases in the guidance mentioned, like the idea of hoverovers and, links to more, how you balance that in a way that, from a legal compliance standpoint, you want to make sure you cover the real estate, but also balance out, like, how do you get folks to read that? Like, how do you try and, achieve that at the same time?
I think the record keeping, I know it's not a riveting topic, but it's particularly hard in digital advertising because the sort of marketing companies will, they will optimize for search, and it might be on Facebook, and there might be multiple variants of the advertising, and the appearance of the image relative to the text may vary. So you end up having to keep like a manifold of records for every little thing, and I'm sure they hate working with us for that reason. They're like, I'm taking screenshots all day for you guys. This is very, very time consuming. But I think that in order to make sure that your advertisers or whoever's sort of displaying your ads are doing so in accordance with your reviewed material, you can't simply just rely on them. You have to sort of keep a contemporaneous record of the way that they're displaying your ads.
And where?
And where? That's right.
Yeah, so the question is, how do you balance the tensions between what type of information you're supposed to provide about your model against the advertising rules and all the rules they have about backtesting and hypothetical performance?
Yeah, and I think when we were talking about backtesting earlier, it's certainly we do see backtested or model performance that's reflected in advertising materials, and there are disclosures that need to be made around those. I think when we were discussing backtesting of the model, or at least when I was talking about it in the context of the compliance program, it's more to ensure that if the firm has a white paper that says we perform tax loss harvesting for you, or we, fill in the blank with whatever the service is, that the model that's been that it actually performs as expected, and is actually taking or matching, I think, what the firm is putting out in terms of the services that it's providing. So that was sort of where I was going with those comments. Does that make more sense? It does, okay.
But at the end of the day, it's still a model. I mean, you're still, even if it's a white paper and you're showing research, it's still part of the model. So, I guess maybe that white paper distinction is a part of that.
Are you asking about like how you present performance with these? I think that's a great question. I mean, and I think you see a variety of how firms are presenting their performance, and I think because performance can be complicated and is very fact-driven, the disclosures that go with that. Usually, when you're looking at whatever on a piece of paper and you're looking at a performance table, there's a whole bunch of disclosure that's following that performance table, especially if it's hypothetical, index-based, and how you manage that in a digital space is a challenge.
So I think what we would look for in exams is just if there are certain assumptions or if there are limitations, that those are, clearly described in plain English so that people can understand what is or isn't reflected in the performance that's being advertised. One kind of obvious example, and I think there have been cases in this regard, if for instance, the performance is being reflected gross of fees, which may have a material impact if fees are taken out of that performance. I know here the fees are less maybe than with some other advisory models, but I think just having a very clear disclosure of any of the assumptions and limitations. And we had talked a bit earlier about in a digital environment, how do you ensure that you're giving enough real estate to those disclosures so that there's sort of equal prominence with all of the good information that's put out, or the advertising that's put out. And I think just finding a way to do that. And I think the guidance, suggested the hover-overs and the tooltips and other ways that type of disclosure could be placed there so clients are getting a fair and balanced picture.
I think another important point is in most of the situations you're dealing with portfolios that have not been around very long, and how you balance the, especially if you're like using index-based performance or things like that, where you may be showing charts that show, okay, 15 years, but your portfolio has been around for 3. From a disclosure standpoint, making sure you cover that ground, so you don't give the impression that, oh yeah, my portfolio has been around for 15 years to the customer.
Yeah.
So in the last few minutes, I just want to get to a question that we got over the app. It's not on our unique challenges list, but it's about Rule 3A4 of the Investment Company Act, which, for those of you who aren't familiar with the rule, basically is an exemption from investment company status where you have a manager managing a whole bunch of accounts in the same way. And basically says if you do certain things to show that you're providing some sort of individualized attention to these accounts, then you don't have to treat them all as forming one investment company. And there's been, I think, a fair amount of discussion in the robo-advisor space about how you comply with Rule 3A4 when you've got these types of models, and you're essentially managing lots of accounts in what looks like the same way. And so I just want to ask the panel to respond to the question, and with I guess how you deal with the Rule 3A4 challenge in your business, or else in how the SEC has been viewing it.
Yeah, I don't see it as a challenge because we don't, and this is not for legal reasons, we don't manage all portfolios in the same way. We review every portfolio every day, and we rebalance it in and of itself to the target portfolio, and end up having great dispersion between the portfolio composition, just in tickers, not in the returns. Returns, everything's aligned. And so a large number of our clients will ACAT in their positions. I guess I should just highlight that I can't speak to what our competitors do, but one of our unique implementations is that we don't sell all of your positions and start from cash. And so I believe you would have that, managed pooled investment vehicle type of recharacterization risk if you were to start everyone from cash and then rebalance everyone at the same time in the same manner. We, by technical design, do not do that. So, so I think it's not a particularly pronounced issue for us as a firm.
I do think it's a bit of a challenge with an automated offering. Some of the ways we've approached it is through, you can, whether you offer other options in terms of your sweep vehicle, arguably whether tax loss harvesting capability can help as well. The idea of, again, if the customer kind of can sort of opt out and choose a bit of a different path, that's another approach to potential further customization. But I think this is an area that there could be more guidance, and based on the inspections, you all may be seeing things that you like and don't like in the space. And it's a rule that hasn't really had any guidance for many years, right? So I think it could use some further guidance.
I'll just note, it's definitely something that we are looking at as part of our exam initiative. And I'll note that in the IM guidance update in February of 2017, IM encouraged industry participants in this space to reach out if you're interested in further guidance or if you're having difficulty kind of thinking through some of these issues. So I would encourage you to do that.
Okay, I'd like to thank the panel. Thank you all for listening.